I've got a story from Jefferson's second term in office from 1807 to 1809, where it was the other way around. There were states and individuals taking all kinds of actions to try to nullify in practice and effect the Jeffersonian embargo, the Jefferson embargo of 1807, and a bunch of follow-up acts over the next 2 years. Kicking this off here from Dave Benner. This might not be the fastest of Fast Fridays, but since I missed a show on Monday, maybe we can make up a little bit of time. Here from Dave Benner. The Embargo Act of 1807, which was signed on December 22nd of that year, it was kind of hush-hush. It was just kind of shoved through a little bit. It was passed at the height of the Napoleonic Wars in Europe. Dave writes that Jefferson and the Republicans hoped to use the embargo to preserve American neutrality and avoid foreign entanglements. So here's the very quick background. There's a lot of reading you can do on this, and I'm just giving you the overview here. Dave puts it this way. In France, Napoleon had enacted the Continental System, which prohibited the importation of British goods into Europe. The British responded by imposing their own trade restrictions against the French. And during this time, British actually antagonized supposedly neutral U.S. shipping. And so they used this practice of impressment. They treated U.S. ships as if they were enemy ships. And Dave says this situation culminated in the Chesapeake Leopard affair, where a British warship attacked and boarded an American frigate and captured its crew. So there was a lot of outrage. So Jefferson really was trying to going out of his way to stay in a state of peace, not wanting to get into open conflict with the British. At some point, I get the impression that he at least wanted to push things off as long as possible. It did end up in a full-scale war with the British eventually, so I'm not sure if he was aware of that. I know that he was writing some years later. He thought he could just go 2 more months, kind of like the 2 more weeks that we've gotten in recent years, and he would have been successful, but it didn't work out that way. And so by going with the Embargo Act of 1807, this was the middle ground instead of just complete submission and the other end of a total war. He thought that he could use kind of an economic warfare to get them to back off from doing this. But this opened him up to charges of unconstitutionality and nullification efforts by individuals and states. A quick overview from Wikipedia. The initial legislation, December 22, 1807, it put an embargo on all ships and vessels under U.S. jurisdiction, American ships. They were prevented from obtaining clearance to undertake in voyages to foreign ports or places, but the president was given some discretion with this. He could make exceptions. He was authorized to enforce it to revenues via instructions to revenue officers and the Navy. He did use the Navy on this. And it turns out that there were some loopholes. Now, first of all, before getting to that, I want to point out that the greatest opposition to this actually came from New England, of course, the kind of the more economic centers, and the Federalist Party, who was they were out of fashion at that point, but this actually got them to build up some strength again. But there were some old guard Jeffersonians who were vehemently opposed as well, like John Randolph of Roanoke. Dave Benner points out that Randolph thought it was unconstitutional. I've read some of the text that Randolph said. I guess it was in Congress. He basically took the position, and I'm no expert on his views, but my understanding is he took the position that the Constitution was there to kind of promote commerce, not to shut it down completely. So he was taking the position that this was an absolute no-go. And if you're looking up on the screen here, I will link to this in the show notes along with everything else over at 10thamendmentcenter.com/path-to-liberty. This was a very popular political cartoon hammering on the Jefferson embargo. They just flipped the word around to, if you flip the embargo around, it's "oh, grab me." So you can see how there's this turtle grabbing someone who wants to do trade with other people and trying to stop them. I will link to that so you can check it out in the show notes. Now, I was mentioning John Randolph of Roanoke. This would have been an old guard Jeffersonian. But there's also Albert Gallatin. Now, Gallatin, I don't find any evidence that he thought this was unconstitutional. He was Jefferson's very trusted Secretary of the Treasury, but he did take the position that this type of approach isn't very effective. Here he is in a letter just days before it was signed into law, December 18, 1807. I prefer war to permanent embargo. And Jefferson gets into that a little bit later the following year as well. This one, I think, really hammers home a lot of what we live under today. Governmental prohibitions do always more mischief than had been calculated. That's something we should pay attention to so much more. There's all these unintended consequences every time they prohibit you from doing something, growing something, owning something, buying or selling. It does so much more harm. And that's why Gallatin was taking the position, look, we can't, if we're going to do this, it's got to be short term. Because if it goes on forever, it does so much harm to our country, to our people, etc. And he goes on, he closes out this letter. As to the hope that it may induce England to treat us better, I think it entirely groundless. So Gallatin didn't think it would be very effective. Now, weeks after passage, they actually passed what was called a supplementary act. They passed a series of acts going forward here, adding some more enforcement. And here from Wikipedia, as Forrest McDonald, who's a great historian, wrote, a loophole had been discovered in the initial enactment, quote, namely that coasting vessels and fishing and whaling boats were exempt from the embargo and they had been circumventing it primarily via Canada. Now, if everyone was on board, for example, if you're thinking of like 1775, 1774 non-importation agreements, there was certainly people who wanted to go against it and they were shamed into basically stopping against the British. But it was almost like the other way around. Every time there was even the tiniest loophole or a possibility of a loophole, people were trying to flout the law. They did not like it. And this might really, really surprise you. Again, not a Friday the 13th trick here, but meanwhile, Thomas Jefferson requested authorization from Congress to raise 30,000 troops up from the current standing army of 2,800. So he wanted to 10x the number of troops so he could use the military to enforce this. He did actually have patrols going and trying to shut it down. Congress actually refused him on this, even though he was very, very much influential on what went through Congress. Here from H.A. Scott Trask over at the Mises Institute, a great article from many years ago, Jefferson's Disastrous Embargo. I'm just going to give you some highlights here from that article. You should absolutely read the whole thing if you want to learn more about this issue and how people responded to it. We can get some strategy from this as well. But here he said, although it was ostensibly designed for their benefit, and that's what it's always sold for, government prohibitions are to protect you, to help you, to save you, etc., the embargo was not a popular measure among the American mercantile class, and they soon found loopholes and ways of evading the provisions of the law. For instance, American merchants began a brisk trade with Canada across the northern border and to a lesser extent with the Spanish Floridas. Interesting. In response, you start getting these things that have the spirit of the resolutions of 1798, Jeffersonian principles of noncompliance, nullification, Madison interposition in Virginia against the hated Alien and Sedition Acts. But now it's the other way around. Instead of the Jeffersonians actually using this type of language against the Adams administration, it's the Federalists in Massachusetts flipping it around. Here's a resolution passed in the Massachusetts legislature. The Embargo Act, is, in the opinion of the legislature, in many respects unjust, oppressive, and unconstitutional, and not legally binding on the citizens of this state. Now, they specifically said, I'm not sure if it was in this particular resolution or another one, they specifically said, hey, don't do active violent resistance to it, go through the courts. But I think really this helped encourage more and more flouting of the law. It's a very interesting strategy, and that's really what we saw. And here back to Scott Trask at Mises. As a result, Congress passed the third Embargo Act. So first you had late 1807, just weeks later at the beginning of 1808, and now another one. It's like a whack-a-mole. If they really had the support of the people, they wouldn't have to keep passing all these laws telling people that they can't do stuff. People would have just been on board. Instead, they have to keep trying to close loopholes. This one forbidded trade by land or inland waterway between the U.S., Canada, and Florida. But massive evasions of the law continued. For example, New Yorkers and Vermonters openly transported products on large rafts and boats across to Canada. So then on April 19th, 1808, this does not sound Jeffersonian at all. We don't normally hear a lot about his second term. Benner called this kind of the low point of Jefferson's political career, but he proclaimed the existence of an insurrection along the northern border, quote, too powerful to be suppressed by the ordinary course of judicial proceedings. So he called on governors in Vermont and New York to call out their militia to suppress the illicit traffic. Ooh, that's pretty aggressive, trying to shut things down. Now, it was being defied all over the place. I want to point out a couple of examples here. There are many, many others. Here from a letter from an American to Thomas Jefferson in January of 1808. Again, this will be linked to in the show notes so you can read it yourself. Quote, it has been discovered that New Orleans has been decided not to be within the letter of the law, being only a territory in consequence of which orders have been sent from here, and no doubt from other places, to purchase large quantities of cotton, flour, and other produce in the port of New Orleans and ship them to Europe or the West Indies as interest may suit. So they're saying, hey, we're not even a state, we're just a territory, so this doesn't apply to us. They're finding any way to take the position that they don't have to follow it. And then they're encouraging people to ship stuff through the port of New Orleans, and then there is no embargo. Here's another one from Albert Gallatin, again, the Secretary of the Treasury, to Jefferson the following month. He said, Brown, the New Orleans collector, writes that he had cleared 42 vessels. Now, the number was supposed to be 0. Cleared 42 vessels since the embargo was known because he had no copy of the law. So this guy is basically saying, I had no idea this was law. And Gallatin goes on in the follow-up in that paragraph say, well, it's pretty obvious that everyone else knew about it around there in New Orleans, but well, we got to do something about this. And then in March, the following month, Gallatin writes to Jefferson again, we have no marshal in North Carolina, which stops our business and even prevents serving process on a vessel which had violated the embargo. In April again, he writes again, talking about North Carolina. They can't do any arrests, so people are openly defying it. They can't do much enforcement at all. Now, in the months to follow, Jefferson, I think in April and May or so, Jefferson repeatedly had letters to other people on this, suggesting over and over that at some point Congress might have to decide if the embargo was still going to be preferable to war. And that gets back to what Gallatin was talking about just before it was signed into law. He preferred war to a permanent embargo. How long is this one going to go before they're choosing, well, we got to go to war? So the noncompliance continued throughout 1808, and at the beginning of 1809, Jefferson signed another enforcement act. I think this was the second enforcement act specifically, that gave the collectors and marshals even more latitude in searches, seizures, and detentions. Here again from Trask. Over at Mises, federal officers were now authorized to search any vehicles of transportation or warehouses and to seize and hold specie or other articles of domestic growth, produce, or manufacture, which they suspected were intended for export at any port or location in the Union, not just at ports or locations adjacent to foreign territory. To obtain their release, check this out, this is pretty aggressive. Owners had to give bonds to the full value of the articles. Coasting vessels now had to give bonds amounting to 6 times the value of the vessel and cargo. So cost prohibitive. That's how prohibition generally tries to go. And he says Jefferson, his administration, and the Republican-controlled Congress ignored the protections afforded by the 4th, 5th, and 6th Amendments to the Constitution. You can see how now, even though there was a federal court opinion that upheld this as constitutional, you can see how there certainly were some people in the early days of the Republic that saw this as a violation of the Constitution, similar to how Jefferson, Madison, and the other old guard Jeffersonians saw the Alien and Sedition Acts as violations of the First Amendment, for example, and other parts of the Constitution, 10th Amendment specifically. So they passed this other enforcement act with all kinds of search and seizure provisions. And here from a great old book that it will be linked to online over at constitution.org. Herman Ames, State Documents on Federal Relations. It was State Documents on Federal Relations from 1911. Upon receipt of a circular letter from the Secretary of War on January 18, 1809, requesting governors to designate special officers of the militia, quote, of known respect for the law, to aid in the enforcement of the embargo, Governor Trumbull of Connecticut replied just a weeks later, quote, declining to take the responsibility of complying with the request on the ground that neither the Constitution nor the statutes of this state, nor the Constitution or laws of the United States authorize such an act, And it also stated that, quote, the great mass of the citizens of this state regarded enforcement of it as unconstitutional in many of its provisions, interfering with state sovereignty and subversive of the guaranteed rights, privileges, and immunities of the citizens of the United States. So Connecticut is saying this is unconstitutional. It violates our rights, and we're going to decline to help you to participate. So then he called a special session of the assembly to oppose the act officially. And they passed something probably within I don't know the exact date, but pretty quickly after. And here's a quick quote from Connecticut. That to preserve the Union and support the Constitution of the United States, it becomes the duty of the legislatures of the states in such a crisis of affairs, vigilantly to watch over and vigorously to maintain the powers not delegated to the United States. Sounds very similar to Jefferson's view in 1798. We don't believe that this is authorized, and therefore it is the duty of the state legislature to guard over this and do something of it. Maintain the powers not delegated to the United States, but reserved to the states respectively or to the people, and that a due regard to this duty, that's what Madison called it in the Virginia resolutions of 1798. The states are in duty bound to interpose to arrest the progress of the evil. They're using the same language. The people that a due regard to this duty will not permit this assembly to assist or concur in giving effect to the aforesaid unconstitutional act passed to enforce the embargo. They were really mostly opposed there to the Second Enforcement Act. That was in Connecticut. Also in Delaware, we consider the embargo as a war measure. So you may have heard me mention that in many situations, sanctions can be seen as an act of war. Now, it depends on the scenario and how it's applied, but certainly they were considering in Delaware. The legislature passed this on January 30th, 1809. They consider it as a measure of war. We consider the embargo as a war measure. So if you can't do a war measure without a declaration of war in and of itself, a war measure would be unconstitutional. It's worse than futile as a measure injurious to ourselves, destructive to the best interests of the country, and evidently intended to be partial in its operations against the belligerent nations. If you listened to my episode or watched it from Wednesday when I talked about the foreign policy views of the founders, where all the founders agreed that they were basically following Vattel's Law of Nations, and you couldn't take action against one or the other side of a conflict that provided favors to one or the other, or basically favors to one to the exclusion of the other. And that's really what it gets to here as well. So it's intended to be partial in its operations against the belligerent nations, and it becomes the United States a great and gallant nation to defend its rights in a manly and efficient manner. Now, some people were saying, just like Gallatin, John Randolph at Roanoke, basically, at some point I was reading, he basically was looking at this like, if you're saying we're going to shut down our commerce in response to you trying to stop us from having commerce with another country, this is basically unlimited submission. This is not becoming of the United States. Going further, Delaware put, we consider the act to enforce and make more effectual as an invasion of the liberty of the people and the constitutional sovereignty of the state governments. Now, talking about how they saw this as a wartime measure, William Jarvis, in a letter to James Madison, talking about a possible embargo in August of 1807, actually put it this way. A general embargo may be conceived advisable, thinking, we could do this strategically, lest England should consider a general non-intercourse as a virtual declaration of war and consequently seize all our merchantmen on the high seas. So there was an understanding, at least from Madison, Jarvis, and others, that, even if we think this is a good policy, they may see it as a virtual declaration of war, and therefore we're running into a lot of problems. And that's the same position that Delaware was taking in 1809. Now, here's another one from Rhode Island. Rhode Island passed a resolution in 1809 as well. The several acts of the Congress of the United States laying an embargo by the permanent interdiction of foreign commerce and by the numerous and vexatious restrictions upon the coasting trade do, in the opinion of this General Assembly, infringe upon the undeniable rights and privileges of the good people of this state, and that the act of Congress on the 9th of January last, enforcing the several embargo acts, is in many of its provisions unjust, oppressive, tyrannical, and unconstitutional. They talk about how it's their duty, again, to preserve the Union, preserve the Constitution, ensure the powers delegated and reserved are the way they're supposed to be. And whenever the government goes beyond its limits, there's a duty to do something. Now, here's an interesting irony. If you think about this, what's going on here? It's the Federalists against the Jeffersonians. Not all. There were some old guard Jeffersonians, old Republicans that were against this as well. But it's flipping things upside down from just one decade earlier in 1798 with the Adams administration, Virginia and Kentucky resolutions against the hated Alien and Sedition Acts. But here's John Adams. John Adams, you would think, would not be on the Jeffersonian side in just about any situation. I think he had an interesting position. Here, a couple letters, one to Benjamin Rush in February of 1808. He points out that the clamors against the embargo are no doubt intended to disgrace Jefferson's administration. He thought that his fellow Federalists were just doing this for, well, trying to win some new seats in office. And he said almost the same thing to William Steuben Smith just a couple of months later. Grumbles at the embargo appear to me to be mere electioneering artifices. So I thought that was a pretty interesting thing. Here's Scott Trask one more time over at Mises Institute. Now, in 1808, I mentioned there was a federal court opinion upholding the embargo as constitutional. But Trask points out that, well, this is kind of a Hamiltonian John Marshall approach. It didn't get to the Supreme Court. But check this out. There was great irony in the fact that the major judicial decision upholding the constitutionality of the embargo was rendered by a New England Federalist, Judge John Davis of the Federal District Court for Massachusetts. His opinion in September of 1808 drew on all the expansive constitutional doctrines first advanced by Alexander Hamilton in the early 1790s. This was to establish the national bank, which Jefferson opposed vehemently in 1791, pointing out that to take a single step beyond the bounds thus specially drawn around the powers of Congress is to give them a boundless field of power, no longer susceptible of any definition. I forget exactly how he put that. Basically saying, as soon as you give them a single step, even if you think the bank was just one small thing, he thought that was a huge deal at that time. So things tend to flip around based on who's doing it and who's in power. But this federal district court took the same position that Hamilton did in the early 1790s. He spoke of, quote, the discretion of the national government with regard to locating the proper bounds of the commerce power. So it was just up to the federal government to determine how much power they had under the commerce power. Very Hamiltonian, very much John Marshall. He cited, quote, the necessary and proper clause as authorization for the power to lay an embargo. He invoked a doctrine of inherent sovereignty, which was simply the doctrine of implied powers by another name. And get this one. Trask puts it this way. In a sentence that should have sent Jefferson rushing to repeal his experiment in what Jefferson called peaceable coercion, Davis wrote that, quote, in our national system, as in all modern sovereignties, it is also to be considered as an instrument for other purposes of general policy and interest. So in other words, even if you're limited to doing certain things as described in the ratification debates, you have all kinds of other implied powers that we never discussed in the past. Again, Davis wrote that in our national system, as in all modern sovereignties, national system, not a federal system, it's a national system with all kinds of executive power. The commerce power is also to be considered as an instrument for other purposes of general policy and interest. And they certainly claim almost everything is commerce today. Like I said, I was going to go a little bit long on this so-called Fast Friday episode, but I hope you found this interesting. I hope it was educational. More important than anything, I hope you learned something. If you want to help us get this kind of historical lesson, plus all the other stuff that we do, teaching people about the original legal meaning of the Constitution and how to defend and support it when the government refuses to do so, which is constantly, nothing helps us get this work done more than the financial faith and support of our members. You can join us over at 10thamendmentcenter.com/members for as little as $2 a month. We also have annual, lifetime, and 5-year options. So if you got some of that dirty government fiat laying around, throw it our way. Again, 10thamendmentcenter.com/members. Again, I really appreciate you being here. I appreciate you sticking around a little bit longer than normal on a Friday. I hope you enjoyed the episode. I hope you have an awesome weekend, and hope to see you next week here on the Path to Liberty.